G'day, it's Josh here from Boorman Lawyers. I'm just outside Albury local court where I've appeared on a high range drink driving offence. The blood alcohol reading was 0.157. Nothing significantly aggravated about this matter. Our client, originally from India, he's been here for the past 10 years, since 2014. He resides in Melbourne, but on the night of the offence in late January, he did come up to Albury region to meet up with his cousin. Went to dinner with his cousin, had some drinks, went to drive and stay at his cousin's place in Lavington, and yeah, on the way there he was seen doing a U-turn, which probably wasn't all that kosher. He wasn't charged with performing an illegal U-turn, but that gave him a reason for the police to pull him over and breath test him very late at night, 2:30 a.m. in the morning. It was a positive reading and a final BAC of 0.157. Nothing significantly aggravated about the matter. I mean, aside from the U-turn, it was very late at night, no other pedestrians or cars around. He was the sole occupant of the vehicle. He wasn't speeding, driving erratically, nothing untoward like that. He had a very good traffic record, one speeding offence in 2019 in Victoria. And he went and did the traffic offenders program. He works as a concrete truck driver, so since being off the road, he has been unable to work, which has caused him significant financial problems. Very remorseful, put before the court a letter of apology, got some good character references. But yeah, first offence and relatively low level of objective seriousness despite the reading falling into the high range category. There was a fair bit of discussion between myself and the bench today about the interlock. This is a matter that has occurred in New South Wales, a New South Wales offence. We're at a New South Wales court. Our client resides in Victoria and at the time was on a Vic Roads, a Victorian driver's licence. So the kind of technical issue that popped up was whether an exemption for the interlock should be granted. Now, Victoria might have their own ideas about if my client goes back and tries to get a Victorian driver's licence, about penalising him again in their state for this offence. But for the sake of being penalised in New South Wales, if he was given the mandatory interlock order, which he was unable to do because he resides in New South Wales and was unable to get a New South Wales licence, interlock licence, and if he failed to do that interlock period, then he would be put off the road for a mandatory minimum of 5 years. So that would have been an extreme level of hardship. For the sake of any sort of complication like that, the magistrate today granted an exemption of the interlock, and that did increase the period of disqualification. It doubled it for the minimum period of 12 months, which was backdated. But at the end of that period, my client is free to go and be relicensed again and doesn't have to do the interlock program in New South Wales. So it's a lot cleaner approach we got today. He's very relieved and happy to now move on with his life. And I think being a first offence, one prior speeding entry in 10 years, extremely unlikely we'll see him back before the court again. But thanks for tuning in here at Albury local court in the very, very southern part of New South Wales. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.